This will be an employment law update by Laura Stover. She is the Director of HR Advisory Services. She sits in the Chambersburg office, joined SEK in 2011 with more than 25 years of experience currently. She graduated from Shippensburg University with a bachelor's degree in human resources management, and she leads HR advisory services and provides HR outsourced solutions to clients throughout the firm. Laura, I'll turn it over to you.
Okay. Thanks, Christina. Well, good morning, everyone. So we are going to start the morning off with some HR information, and specifically, I'm going to be doing some updates from a federal employment law perspective. What we're going to look at is making sure you're using the current I-9 form and also talk about some changes with the penalties. We're going to look at the EEOC and how things are kind of changing with that. Review the independent contractor rule status under the DOL, which seems to keep changing back and forth. We're also going to talk about artificial intelligence and having a policy. I know, there's a lot of talk out there about AI, and sometimes it's a little exhausting, but it is super important that your organization is paying attention. And then we're going to finish up talking about a couple Department of Labor opinion letters on wage and hour issues and FMLA. And then I'll end the presentation with just some next steps for you to do to make sure that your organization is in compliance. Okay, so I wanted to share that the current I-9 form out there has an expiration date of 5/31/27. And there's a couple editions out there. If you go out on the website, I've provided a link. There's the 1/20/25 edition, but some of you may also be using the 8/1/23 edition, and you want to be careful with that because it has two expiration dates. It also has the 5/31/27, but there was another printing where there's a 7/31/26 expiration date, which is in just a few days. So I encourage you just to double check to make sure that you're using the correct form. You can see the expiration date up on the upper right hand side of the form and the edition on the bottom left. So go ahead, and take some time and look at what you're currently providing to new hires. So I also want to talk about violations and penalties. There's two types of violations out there if you are ever audited, if you ever have an I-9 audit, and that is a technical violation and a substantive violation. And historically, with technical violations, these were typically minor violations that you could correct and fix by correcting the form. You remedy by correcting the form. And a substantive violation were serious. Those are paperwork errors that are so severe, it appears that the employer failed to discharge its duty to actually verify that the employee was legally able to work in the U.S. And substantive violations carry fines of $288 to $2,861 per form, so they can be pretty costly. Well, what happened recently is ICE revised the list of what's actually considered substantive violations. So things that used to be technical are now more serious. And I wanted to provide you some samples of this. This is not an all-inclusive list, but these things now can cost you money if you're audited. For example, in Section 1, if the employee doesn't provide their date of birth, or they don't list an alien registration number, if that's applicable, or even if they don't put a date next to the signature, those are all now substantive. On the second section there, that employers complete where you put the documents in, if you don't complete that fully and correctly, even if you have a copy of the documentation, that's an error. If you don't put that first day of employment in that certification section, that's now substantive. And if you're using the remote documentation verification process, but you're not registered with E-Verify, that's now a major violation. So I really encourage you, this is a great time to take a look at your I-9s. I provided a link here that the government has that explains how to do an audit. I can share that every time I've reviewed I-9s for a client, I've never had a client that's getting it all right. It's really easy to make mistakes on this form, especially if you're not doing it through software or you don't have someone like an HR person who's been trained on how to do it properly. So I really encourage you to go ahead and take a look at your I-9 forms. Go ahead, Christina. So the Equal Employment Opportunity Commission, I wanted to just talk about the commission a little bit because it's obviously a major organization when it comes to discrimination and harassment laws. And for a long time, they didn't have a quorum due to the current administration terminating some of the commissioners. But this last October, they finally got their third commissioner. And what that means is the EEOC can now, issue official guidance. They can issue new regs and approve major litigation. And since that's happened, we've seen really an immediate shift from the prior administration workplace policies. And I wanted to provide just a few bullet points on some things that are potentially changing to give you a feel for what the current EEOC looks like. I don't know if you remember last year, for those of you that were on the call, I talked about the enforcement guidance on harassment in the workplace. Last year, parts of this were struck down by a court. It was areas that talked about sexual orientation and gender identity. And we kind of thought that, it would be reissued without that information. But actually, the entire guidance has been rescinded. And the guidance was a really nice tool that had a lot of examples and benchmarks in it and was super helpful to HR people as well as leadership and management in organizations to help understand how to handle harassment and discrimination guidance. And that's now gone. So, we're going to be relying on older materials or whatever the current EEOC puts out in the future, but that's no longer available. The EEOC is actively investigating diversity, equity, and inclusion initiatives and programs. So if one group is somehow preferred over another, or there's quotas or selection preferences, that can be considered unlawful discrimination. As always, it's important to treat people equally and be inclusive. An example of some litigation that's out there right now is a Coca-Cola beverage bottler in a Northeast case. What they did was they held an off-site retreat for women, and it was about a day and a half long. It had networking and training, and it was just invitation only to women. There was about 250 women that attended. And a male employee, issued a complaint that men were not able to attend this training. And the EEOC has actually taken on this case and said that they believe this is sex discrimination against men. Coca-Cola is saying, hey, you can't prove there was any measurable harm to male employees by not going to this event. And that's the legal standard. You have to prove that harm. And also that this happened in 2024 before the current EEOC. And that case is out there right now. It's, being debated in the courts. And that just kind of gives you a feel for the kind of things we're going to be seeing going forward. Probably a lot of, what you would call more reverse type discrimination claims. But bottom line, it's important just to remember that you always want to be non-discriminatory and inclusive in, everything that you do as an employer, especially with your hiring and your opportunities. The Pregnant Workers Fairness Act, that was passed back in 2022, and it covers employers with 15 or more employees. It really has some broad protections currently for pregnant employees. And there's some potential changes coming to that. The EEOC is looking to remove menstruation, infertility, abortion, and menopause as covered conditions, and just redefining what's related medical conditions when it comes to pregnancy and childbirth, and really focus on that more than the broader aspects of female reproductive health. So what they're really looking to do is narrow the law so that there's not such broad protections for pregnant employees. So that's, kind of the feel right now. Nothing has changed at this point, but just wanted to make you aware of that. And you may have seen some emails about EEO reporting. There's proposed rulemaking out there to take it all away. And that's EEO 1 through EEO 6. Now, it hasn't gone through yet, but it's possible that that's going away. So please continue to do your EEO reporting, but be aware that, this reporting that's been done for a very, very long time may actually be going away. So hopefully, those bullet points give you a little bit of a feel for how the current EEOC is going to be looking at things going forward. They did issue a new national enforcement plan. I put a link down here. If you'd like to dig a little deeper and understand where things are going, you can take a look at that link. and review that information. So there's a survey up there if you want to remember, a poll up there if you want to remember to take that. I also wanted to touch base on the DOL independent contractor rule status. And I know I've talked about this on and off over the last few years, but it keeps changing from the last Trump administration, from the Biden administration, and now we're back to the current Trump administration. And basically, there's a 6-factor test, and none of the factors carry any weight in terms of determining independent contractor status. Well, there's now a proposed rule out there to go back to what the Trump administration had said initially. We want to focus on just 2 core factors. So when you're trying to determine, if someone is going to be a 1099 employee, independent contractor, or a W-2 employee under the Department of Labor, they're saying look at 2 main factors. The first is nature and the degree of control. So if an independent contractor, they're going to be an individual that sets their schedules, they choose their assignments, they work with little or no supervision, and they typically perform work for others. If that's not the case, then you're more likely looking at an employee-employer relationship and not an independent contractor. The second factor is opportunity for profit or loss. And basically, if the person can earn profits or incur losses based on their own initiative or management or investment in the business, that's going to lean towards that independent contractor status. So we're waiting to see if this rule goes through. There's a good chance it's going to go through in the fall, at the end of 2026. And that would mean employers really can focus on these 2 factors. Now, if they point in different conclusions, there are additional factors to look at, like how much skill is required. What is the degree of permanence of the relationship? How the work that the person is doing, how closely integrated is it with other employees? So we shall see, but this is probably where the independent contractor rule is going for now. This is a DOL rule. Remember, the IRS has a test as well, which you can review on their website. And they discuss behavioral control, financial control, and type of relationship. So there is some similarity there, but you want to make sure you're aware of both rules. Usually I see misclassifications when someone's hired part-time or seasonally, or someone's hiring like a consultant, they automatically assume that would be an independent contractor versus an employee. So you just want to be careful with those situations and really take the time to focus on the factors and determine if they truly are an independent contractor. And of course, having an agreement in place with an independent contractor is important as well to make it very clear on what the status is. And again, I provided a link to some more information if you want to read more on that topic. Okay, so I'm going to talk a little bit about AI. I know it's out there. I know you hear about it. It's all over the place. It's talked about constantly. It can actually get a little bit annoying, but it's really important that you're paying attention. And your employees are using it. They're using ChatGPT, Copilot, whatever is out there, and that puts you at risk. It puts your data, the confidentiality at risk. And we all know how inaccurate AI can be. It can be a really great tool, but it can provide outdated information. It can even be discriminatory. There's a lot of litigation out there with people who are using AI and things like hiring practices and making schedules, and it's just causing problems. So it's important that your organization takes it seriously and has oversight for AI in your organization. And you want to get a written policy in place. Even if you don't, permit its use, you want to have a policy stating that. And in your policy, of course, you want to define what AI is. There's lots of the generative intelligence things out there, but there's also bots and AI tools within software that you use. So you want to be really clear in your policy on what AI is. You also want to be clear on what use you approve, if any. Employees need to understand what the boundaries are with using AI. clarify, the importance of confidentiality and data protection, that there's still a human oversight requirement. And also that if you're using AI, you're still responsible and accountable for accuracy in your work. You can't just say AI, gave me the information, it's good to go. And it's important that employees are disclosing when they're using AI for work product. And you want to be clear on actually which tools you allow, if any. If you don't have a licensed tool, you want to be really careful about what you allow to be used and what you allow to be put into it. Because, just general AI out there, your information is just out there. It can be, taken by anyone. Record keeping requirements are important. What do you expect when someone uses AI? Do they have to retain that documentation? And I know there's also some legal cases out there right now where is that discoverable when it comes to litigation. And of course, you want to make sure that you have enforcement in there, the consequences of noncompliance. So employees are really clear and know that you're serious about the AI policy. Bottom line, AI is a really nice tool and it can certainly help us, but it just can't replace judgment. So you want to make sure that you're always maintaining human decision making, in your organization when you're using AI. And it's not going away, so don't ignore it. Make sure that you're definitely have a focus on it. Okay, the last slide I wanted to talk about here are Department of Labor opinion letters. Every year, the DOL issues opinion letters on wage and hour issues and FMLA issues. And what they are is an employer will ask a question to the DOL and then they will answer it in these letters. And it's super helpful because it's considered official guidance and you can use it to interpret issues in your own organization. And I provided a link up here where you can search on opinion letters. So if you have a wage and hour issue or an FMLA issue, and you're just not sure how to handle it, you can always go out there. And for example, let's say you're not sure how to handle travel time. You can put travel time in there and it'll show you questions that have been submitted by other employers and what the DOL has issued as guidance for how to handle those situations. So it's just another nice tool for employers to have when they're trying to figure out how to handle wage and hour and FMLA issues, which we all know can be very, very confusing. So I just wanted to touch on a couple or four actual letters that were sent out this year that I thought maybe have some relevant information for people on the call. There was a question about meals. And when an employee voluntarily leaves an employer's premises, the employer is not required to pay, sorry, I think there's a typo there, for the meal period or the time spent leaving and returning to the employer's premises, provided the employer allots a 30-minute uninterrupted meal period, which may be taken on premises. So there was a question about if someone chooses to go off site, maybe it's a long walk to the car, a long drive to get food, or they have to go through security. There's things that take time. Does the employer have to pay for that, or is that included in the unpaid meal period? And it does not need to be paid. It would be unpaid. I thought that was interesting. Exempt versus non-exempt. This was a question about someone asked, hey, I looked at a position. I think it falls under the professional exemption, but I don't want to make it salaried. Is it okay? Can I make them hourly, non-exempt? And the answer to that is yes. As long as you track hours and pay overtime for over 40 hours in a week, you can do that. And I think this goes back to what's important to remember when you're classifying jobs as exempt or non-exempt. You're not going to get in trouble when people are classified as non-exempt, you're properly tracking hours and paying overtime. Where employers tend to get in trouble is when they make someone exempt and they make them salaried without truly understanding how to do that. And just as a quick reminder, to make someone exempt, you need to make sure they're making at least $684 a week. They're paid on a salary basis, so they're not taking any deductions for quality or quantity of work. And the job duties they're doing actually has to meet an exemption under the law. So you always want to be careful, but the default and what your safest is to have people that are non-exempt. There was another letter on mandatory pre-shift activities. This was actually a hospital. And for those of you who have rounding practices, whether it's through a time clock or informally through a timesheet, this was about if you do rounding, let's say you round, by the 7 minute. If someone clocks in 7 minutes early, but they are actually doing work during that 7 minutes, you can't just round to 8 a.m. You have to pay them. Now, if they're just, walking to their desk, getting some coffee, talking to people, getting set up, no, that doesn't need to be paid. But you want to be careful. If you have people, non-exempt people that are clocking in, do not round their hours if they are actually working once they get clocked in early. And the last bullet point was on FMLA. So for those of you on the call that have over 50 employees and are covered under FMLA, the one question was, hey, when people are out there taking FMLA and they have to travel to medical appointments, is that time covered and counted against FMLA? And the answer to that is yes. And it doesn't need to be, documented. It doesn't have to say in the medical certification that employee will be required to travel. Employers can count that as FMLA time. The second bullet point, this was from a school district about school closures, and they wanted to know if a school closes for a day or two during the week, maybe for inclement weather, and someone's on FMLA for the entire week, do those days count? Is it a full week of FMLA? And the answer to that is yes. And full week is the key there. If an employee's on FMLA for a full week and the school closes for maybe just 1 or 2 days, less than a full week, yes, that entire week is counted as FMLA. So that provided some clarification as well. And of course, when we're looking at wage and hour and leave issues, we always have to consider state laws as well. But again, these opinion letters, and there's several others that have been put out as well, are just really good guidance and tools for employers to use when you're looking at these kind of issues. So I definitely encourage you to go out and take a look at that link. Okay, so just to summarize, some things to do here to help with your compliance. Check the expiration date on your current I-9 form. I definitely recommend completing an audit of your I-9 forms. That's something we can help with as well if you don't want to take the time to do it. If you have any DEI type training in hiring programs, making sure you don't have any specific preferences in there and that you are being inclusive of everyone. Maybe take a look, good time to pull out your independent contractor agreements and anybody you have noted as independent contractors to make sure they're classified properly and consider that, that 2 core factors is probably going to pass here in the fall. If you haven't done so, look at implementing an artificial intelligence policy. We can talk through that with you as well. If you have IT folks, I would talk with them. And as always, be aware of your pay practices, evaluate those, keep an eye on those, look at your policies, your practices for any concerns based on the recent opinion letters, as well as just general wage and hour law. I find that's an area where most employers struggle with their employees is wage and hour. So that's it. I definitely am available if you would have questions. Anytime, please feel free to reach out. My email and phone number is here on the screen, and I will go ahead and turn things over to Christina.
Laura, we do have one question.
Oh, okay.
When the I-9 expires 5/31/27, do all employees need to complete a new form?
Nope, you do not need to do that. You just need to make sure you're using the new form going forward and that you use the current form at the time that employee was hired.